in the last 12 months, we had other two amendments. One in last June and one very brief amendment, but very relevant last February. And these should be added to the last 8 or 10 amendments we had regarding Concordato Preventivo law in the last 10 years. So the Concordato Preventivo institution has been amended so many times in the last 10 years. And now possibly the law in this proceeding is quite good, and we possibly reached an international standard with respect to restructuring proceedings. So now we have a restructuring legislation that possibly is a legislation of a quite good level compared to the legislation of the other, at least EU countries. The unique concern is the fact that so many amendments in a so short period actually gave the chance to the different courts around the Italian peninsula to interpreting differently the law. So now one of the main concerns for the operators, for the restructuring operators and advisor, is that we possibly have as much as different Concordato Preventivo interpretation as much as we have courts in Italy, because any given court has his specific and peculiar interpretation of the Concordato Preventivo law, specifically with respect to the main institution. Like, for instance, if we're speaking about new finance in Concordato Preventivo, we have an interpretation of the laws concerning new finance in Concordato Preventivo for instance, before the Court of Monza, that is different from the interpretation of the Court of Terni, that is different from the interpretation of the same law given by the Court of Milan, and different from the interpretation given by the Court of Palermo. So this, of course, the law, I would say the Concordato Preventivo institution now is a kind of teenager, okay? We have changed it so much in the last year. So it's not an adult. Is growing well, is a good law. For the time being, we have like different interpretation. Possibly these different interpretations will converge into I want to say not in a unique, but at least in few interpretation, because now it's kind of difficult. When, for instance, you have to manage the restructuring of a company, you have to check with the specific court, which is the specific interpretation of the law. The law is the same for the Italian territory, but you have so many different interpretations. That is a perfect point. When you, for instance, you have to deal with an international investor requesting advice regarding how does work investing into a restructuring proceeding in Italy. This might vary depending on the court where the proceedings is open. So for sure, this gives to the system complexities that sometimes are understood with difficulties by international investors. I think that things are going in the right direction, but I think that we still need time to tune and to define the proceeding into a unique national environment. And this is actually also the request and the aim of the European Commission recommendations. So, for instance, we have the European Union Commission that is asking to all the European countries to try I don't want to say unify, but at least to uniform the bankruptcy law around Europe. And while we are following a process of uniforming the EU insolvency law, we are splitting the insolvency law in Italy, and there is no sense for that.